Welcome, everybody. Thank you for joining us. As is our tradition, we're just going to give it a few minutes before we start. For those who are searching for the Zoom button, trying to log in, so just give us a few minutes. Mandy, who's next to me, is my boss, and Mandy tells me Kabir start, and Kabir starts.
It's going to be much easier today because we are sitting next to each other. I can help them. It's going to be good. It's going to be good. So yes, we will wax lyrical for 30 seconds and then we will kick off the show. So we have finally made it to the same room.
We have.
It's exciting.
Yeah.
So, all right, let us then. I feel I should do some sort of countdown, like a rocket to the moon. Oh, we can do this. Do this.
Is that a new thing?
You can tell it's the season finale. We've taken leave of our senses, so we're now dancing at the beginning of the episode. We can do that in the next season.
In the next season, we can start everybody with the dance, a little dance. I have
hustle.
Only 2 moves, so
we can do the hustle.
The hustle.
Anyway, all right. Let's just get started. Let's do arbitration now, shall we?
Fantastic. Greetings, everybody. Thank you for joining us. It's December, and as you can tell, Mandy and I are in the same room. Huzzah!
Huzzah!
Today is a very special episode for a variety of reasons. We have a very special guest, and that's going to make it a very special episode. We're going to be talking about some cutting-edge issues, again, making it a very special issue. And it's our last episode for season 6. So we have combined 3 things together for something very exciting. And as you can tell, we have something fun planned for season 7. We're putting it as a teaser, so stay tuned. Mwahaha!
That was scary.
That was a little scary and creepy.
That was scary.
So, folks, I'm Kabir Dagal, joined by my fabulous co-host Amanda Lee, as her dentist calls her, or Mandy, as everybody else does. Olena, Mandy and I spent a lot of time for coming up with the TagTime gesture, and it's not this.
It's not the
It's not.
either.
We actually raise the roof like we're in a disco, and so we start every episode raising the roof.
The hustle was kind of appropriate, really, wasn't it, for the disco theme, I think.
A little bit on TagTime. During this webinar series, we have leaders from all around the world who join us and engage in substantive discussions on topics related to arbitration. You, our audience, then have an opportunity to ask them questions. And that's what we're going to be doing in today's episode. As you can tell, we are so cool that we're on YouTube. Mandy, today's episode, I think in particular, and I'm trying to move because we are moving from a little bit of humor to really the reality that we have around us today. And that's, I think, what makes today's topic so important, when we're talking about state immunity and the rules related to state immunity, whether we need to be rethinking the framework that we have. The international regime is a very unique contribution if we look at it in the history of humanity. But the rules seem to have some fundamental imbalances, some fundamental inequities. And how do we confront them? And I think the recent situation really brings some of these issues to the forefront. We're very fortunate that we have somebody who's on the forefront thinking about these issues. Mandy, you're going to have the very tough task to introduce Olena, but I just wanted to express my deep gratitude and thanks to Olena for joining us. Olena is on the forefront promoting the rule of law, promoting amicable ways for us to be thinking about arbitration to address armed conflict and hostilities, and more practically promoting Ukrainian lawyers. And we really, from our heart, commend you for doing that. There is no easy answer to the reality. And I think this is an important step towards a very multifaceted issue. So thank you so much, Olena, truly. Today's episode is co-sponsored by AFIA, ArbitralWomen, Arbitrator Intelligence, the Chartered Institute of Arbitration, the Cairo Regional Center for International Commercial Arbitration, the New York International Arbitration Center, LONDAP, Racial Equality for Arbitration Lawyers, REAL, and of course, the two bodies by our own Mandy, Careers in Arbitration and Our Ballads. Check them both out, they're amazing resources. As we approach the holidays, I think both of them become significant in their own reality. Folks, let me just tell you a little bit of what we can expect. Mandy is soon going to have the really tough task of introducing Olena, after which we hear Olena talk to us about this really cutting-edge topic, state immunity, looking at the rules, looking at what we could be potentially doing. Olena will speak to us for about 40-45 minutes, and then we will have the Q&A. Folks, if you have a question, get your pens ready. Should I say pens or is everything on computers? I'm still stuck up in old age.
I like pens.
You like pens? Okay.
They're, really nice fountain pens.
A nice fountain. Okay, that's something I don't have.
Book signings. That's what you need.
So, folks, it's TagTime at delosdr.org. Once more, TagTime at delosdr.org. And folks, here's our 3 tips for making good questions. The first tip, a question is a question when it ends with a question mark. If it's not, it's a sentence. We don't know what to do with that with Olena, so give us a question. Second, just to help Mandy and me, keep your question to 3 lines or under. It really makes it easy for us.
You're doing it too now,
Am I? It's just
you're doing it as well. I can see.
This is when we're together and I'm just
we start mirroring.
Yeah, exactly. Keep it to 3 lines. I'm trying so hard to keep my hands on my legs.
We do it in unison.
In unison.
We did the hustle. We might as well do this too. Come on.
And the third tip, again, when we have somebody like Olena, who is both a leader in arbitration, but a thought leader, somebody who's really trying to get us to think deep and think critically about very tough issues. The temptation to go outside the topic and to get into non-related issues is high. We would urge you to respect the process when we have somebody who's really thoughtfully trying to engage in these topics. So we urge you to respect that. And with that, Mandy, let me just... Olena, I'm delighted you can come here. We have wanted you to come here for a very long time. The situation being the situation that it was, we didn't know when this could happen. But I think it is really appropriate for us to be closing season 6 and entering into the holidays thinking about these topics. So thank you so much, Olena. And Mandy, on to you to now do the tough task of introducing Olena.
Thank you very much, Kabir. As always, I have the pleasure of introducing today's guest. Olena Perepelynska is a partner and head of arbitration at Integrit's law firm in Kiev, Ukraine. She's acted as counsel in about 90 international arbitrations under various rules, including all of the major arbitral rules. She's also served as arbitrator in more than 70 arbitrations, seated in Almaty, Bishkek, Kiev, London, Minsk, Paris, Vienna, and Stockholm. Where does she find the time?
Where does she indeed?
Olena serves as president of the Ukrainian Arbitration Association. She's a member of the ICC International Court of Arbitration, vice president of ICC Ukraine, head of the ADR Committee of the Ukrainian National Bar Association, and a member of the Global Steering Committee of the Equal Representation in Arbitration Pledge. She's a fellow of the Chartered Institute of Arbitrators. This is a bit where I normally say a fellow, because we're both fellows as well. And it's a really bad joke, isn't it? And a member of its approved faculty list. Olena is also a member of the editorial board of the ICC Dispute Resolution Bulletin. She was tagged by Carita Walgreen-Lindholm. Olena, we are so honored to welcome you to Tag Time today. And without further ado, Olena, the floor is yours.
Thank you very much. Thank you for this introduction. Thank you for this opportunity to discuss this important topic, and separate thanks to Carita for tagging me. I apologize for the choice of the topic. I understand that it's much broader than arbitration as such, but in order to cover all the aspects, we need to tackle this topic more broadly. And given the context of the present situation and the circumstances we are now in, and in any case, global solution to the question I pose will have direct effect to the system of arbitration in general and to enforcement of arbitral awards in particular. And so the war in Ukraine, for obvious reason, has posed many new legal issues. And Ukraine should prevail not only on the battlefield, we should also prevail and win on the legal front. And just as a matter of background, Ukraine is the biggest country in Europe. And the area of atrocities during this war exceeds the total area of some European countries, even combined total area of some European countries. And Europe has not seen a war of a similar scale since the end of the Second World War. And again, to understand where we are now, we need to come back to that situation, because this system we have now was actually created or reformed at that time after the end of the Second World War. And the entire security architecture, the legal order was created back then. And probably it would be most appropriate to look at the Charter of the United Nations Organization. So actually this was organization created specifically to prevent such awful situations in future and to maintain this new legal order. A new architecture of securities. I will quote a couple of provisions from the preamble because it's all relevant to what we are going to discuss today. And also this might sound a bit obvious, still it's important because in terms of casual links between different arguments, we need to understand the basics. Yeah, we need to understand where we are starting. So the preamble of the Charter of the United Nations Organization says, "We, the people of the United Nations, determined to save succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to establish conditions under which justice and respect for the obligation arising from treaties and other sources of international law can be maintained, and for this ends to participate, to practice tolerance, to live together in peace with one another as good neighbors, and to unite our strengths to maintain international peace and security, and to ensure by acceptance of principle and the institution of methods that armed force shall not be used, save in the common interests." I will skip the rest, but the basic is quite clear. This war has demonstrated that the system created after the Second World War to maintain peace, to prevent future wars, to ensure compliance with international treaties and international law in general does not work anymore. Even worse, it allows a state that blatantly violates fundamental principles of international law, including purposes and principles of the United Nations Charter, the preemptory norms of general international law known as jus cogens, including the prohibition of aggression, the prohibition of genocide, the prohibition of crimes against humanity, the basic rules of international humanitarian law, the prohibition of torture. And the state, violating all these and many, many other rules of international law, is still sitting in the United Nations Security Council and effectively blocks its decision regarding this war. Just think of this situation. After almost 80 years of just the creation of this organization, one of the members of the Security Council is in violation of all the fundamental rules the organization was created for. And it's still sitting there, blocking actually effective functioning of this organization. It is a big question, what is the legal grounds for Russia to be there at all? As the places in the United Nations Security Council belong to the USSR, not Russia. And recently, Ukrainian parliament has called all nations to take steps to stop Russia from using the rights and obligations stemming from the USSR's membership in the United Nations, in general, and Security Council in particular. This is really interesting public international law issue separately. We will not go into it today. Just wanted to highlight it and to call other nations to follow the invitation of the Ukrainian parliament. But setting aside this issue, we still see that the states committing a violation of international law, whose actions have been even condemned by the United Nations General Assembly, and whose actions have been recognized in our cases, for instance, as aggression violating the UN Charter, is still enjoying the benefits of the system, which it itself is violating. So again, this is something wrong. This should not be so. Just think of it. And in fact, if you think why it is so, you will see that the system as it was created does not envisage any kind of effective remedy, any kind of effective sanction against such a wrongdoing. And somehow to prevent, I think the idea as we see it now, probably the idea and the counterbalance was that if the countries, or if all the states will cooperate and prosper together, like due to international trade, some common economic interest, this in itself, so this economic benefit and benefit for all the nations would somehow prevent future conflicts. And it worked pretty well for almost 8 decades. And but something went wrong recently, and in fact it went wrong not this year. It went wrong almost a decade ago. So if we're talking about Ukraine, this is of course Crimea is the most and actually Ukraine considers that the war against Ukraine started back then. It was just another episode, but that was a real situation, was a part of one state was annexed by another one, because all other situation where Russian proxies or Russian army was involved in Georgia, in Moldova, actually they did not have such a result as annexation. It was just a kind of frozen conflicts, some unrecognized republics, etc., etc. So Russia was an obvious sponsor of all that, but it did not cross the line of annexing this part of territory of another state. And this line was crossed only 8 years ago with annexation of Crimea. And at that time, the world has almost did not react. So, I mean, properly. There were some sanctions, some concern, condemnation, etc. But I mean, really, proper reaction was absent. And one of the reasons why it was absent, this is because of those economic ties. And it was so, I mean, disadvantageous to the world to take any steps further, because it was adversarial. It was not good for their economy as well. And not only this year, I mean, the world accepted that burden of negative financial consequences. But in any case, even with all that, even with existing sanctions, this does not stop Russia. So after all the calls of the United Nations General Assembly, after all the measures already taken, Russia is continuing its aggressive war in Ukraine. So that means that the system does not work. And as Ukrainian, and actually this is why one of the reasons why Ukraine and Ukrainian parliament has also called other states to support radical reform of the United Nations organization and its Security Council in particular, because it's quite obvious that if it's what we have is not functional properly, I mean, we need to change it. So when everything was good, so if it works, don't fix it. But if it does not work, you need to fix it. And as a Ukrainian lawyer, I have received multiple requests from the victims of this war regarding available legal remedies to recover their damages. You could imagine that the number of individuals and legal entities suffering from this war is growing each day. And the damages suffered by the state and private companies and individuals exceeding hundreds of billions of dollars already. And there is a question how to make Russia accountable for that. And this is not only a question of justice. This is a question of the security and stability of the legal order in general. Because if Russia could somehow avoid liability, not only, I mean, on the battlefield, but financial liability, this would encourage other potential state aggressor to do the same. And if we look what we have now, so we have a continuing atrocity in Ukraine. We have Russia sitting in the United Nations Security Council and in the United Nations in general. We have, until recently, we had three basic legal avenues, at least for discussions with potential claimants, because I will tell soon what are the problems with each of them. So the avenues were European courts on human rights until like the window of opportunities is closed because of the Russian withdrawal from the convention. With that legal remedy, at least the jurisdictional issue looks promising, because this institution has extensive jurisprudence regarding jurisdiction against the state occupying or exercising effective control over territory of another state. And at least this point and this practice and jurisprudence makes the jurisdictional issue at least more or less clear. However, we need to understand that occupation in Ukraine is not quite a stable situation. So it's fast changing reality. So we have territories which were occupied, then deoccupied, then again occupied. So it's really hard sometimes to establish whether a particular territory was under occupation in a particular moment of time. And it's also a separate issue how to prove it. I mean, you might have access to different overview of military experts saying this and that, providing some maps, etc. You might have even some satellite information, but the issue of occupation is not that straightforward when we are talking about military occupation and atrocities. And again, even if the Russian army was there, the level of control could have been quite different. And what they have done until recent annexation, I mean, because annexation is probably turning point in that story, it was quite different. And there were some gray areas where there were like atrocities, and some territories have not could not be claimed as being under the control of one state or another. However, these entities and individuals on that territory suffered from the war, and the issue is who should be accountable for that. We also have Ukrainian territory, I mean the territory under effective control of Ukraine, but we have Russian missiles reaching that territory. So I'm now in Kiev region, which is like a standard target for Russian missiles, drones, etc. So although it's controlled by Ukraine, and another question is, okay, we cannot claim that this territory is somehow under Russian control, but still, how to make Russia accountable for that? And the existing jurisprudence of the European Court of Human Rights does not give us a clear answer on that. And in the end, even if, okay, we go through the jurisdictional stage, we get a decision of the European Court of Human Rights, what we are going to do with that? I mean, Ukraine has withdrawn from the convention. Ukraine has adopted a law saying that they're not going to comply with the decision of the European Court of Human Rights. And technically, I mean, according to the convention and the logic of this institution, this decision should be enforced in the respondent states. And actually, we do not have any international mechanism enabling enforcement of such decisions in other jurisdictions. Another legal avenue is Ukrainian courts, because quite recently the Supreme Court of Ukraine confirmed that it considers that Russia should not enjoy jurisdictional immunity because of what it has done in Ukraine during this war. So now there are a pipeline of cases which is growing before Ukrainian courts against Russia, and Ukrainian court will inevitably render many decisions regarding compensation of damages to the victims of war. There is a separate issue how to properly notify Russia, because now we don't have diplomatic relations, we don't have postal connection, we don't have courier connection, so there is no physical opportunity to physically deliver anything from Ukrainian territory to Russian territory. So we have only emails and publication of website of Ukrainian court system. That's it. But that is like separate issue. We still have a big question mark what we are going to do with those judgments. So because quite obvious answer that when we will not be able to enforce it in Ukraine, because in Ukraine, the Ukrainian state has already confiscated or in the process of confiscating everything belonging to Russia. And private claimants are not in a position to compete with the state. So the only opportunity is to go abroad, and in other jurisdictions, we will have an issue of sovereign immunity. Turning to the third legal avenue, potential investment treaty arbitration, which is quite not an obvious option, I mean, as a reaction on the war. But I would not say that you would expect normally to go to that tool when you have a war. But Crimea jurisprudence has proven that you could look at the text of the treaty from different perspectives when you have some unexpected circumstances. And the difference with Ukraine, and particularly Russian-Ukrainian BAT, was that after annexation of Crimea, many Ukrainian claimants, which were basically domestic investors when they were making the investment in Ukraine, they launched investment treaty arbitration under Ukraine-Russia BIT against Russia, claiming that as Russia has effective control over Crimea, it should be a respondent state under the BAT and should pay compensation for the assets which were expropriated and other violations of the BAT. And I remember first discussions 8 years ago about this case, and there were many skeptical views that, okay, this would not fly. No tribunal would be inclined to satisfy such claims or even to confirm jurisdiction. But after 8 years, we see that all the tribunals confirmed their jurisdiction and rendered awards in favor of the claimants. Just today, I've read the news from the Ministry of Justice that one of the biggest Crimean awards, an Bank case, was confirmed by the Supreme Court in France. So as you might know, so that award was set aside by the Court of Appeal. And now the Supreme Court set aside the Court of Appeal decision and confirmed the award in Bank case. This is one of the biggest, I think, in Crimean the saga. But nevertheless, so the point is that the tribunals in Crimean cases confirmed that you could read the treaty more broadly, and you could interpret the text with regard to the notion of the territory more broadly. And that is why this inspired many claimants from recent occupations to look whether this could be equally applied to new situation and new occupations and probably newly annexed territories. Until September of this year, when Russia announced annexation of 4 additional regions in Ukraine, many potential claimants from Donbass considers that they do not have any good chances to go that way because Russia claims that it was not there. So it was not part of the, as we call them, green people, military people in Donbass staying behind this self-proclaimed People Republic. And now, after annexation, it's quite clear that, and public statement made by some Russian officials now made it clear that Russia was always behind that. And it is also important that Russia formally declared annexation of the territory within the limits of territorial regions of Ukraine, so irrespective of actual control of the territory, because these are not coinciding realities. So we have administrative borders of 4 Ukrainian regions, and we have fast-moving front line in all of them. So again, this inspired many claimants to look at that option. That option is very expensive. It's more promising in terms of the amounts of damages, and many potential claimants have addressed have asked third-party funders whether they would take a case against Russia because to finance that, because after you've lost many millions of damages or assets, you might be not in a position to invest some other millions in order to get an award. And the problem with all that, with all 3 legal avenues and with third-party funders, is how to enforce these judgments or awards against Russia. And so far, the examples of attempts of different claimants with awards in hands, with multi-billion awards in hands, against Russia are not really encouraging. So we all know Yuko's case, we all know against enforcement saga in Crimea awards. And until now, Russia was very successful in blocking enforcement of arbitral awards against it, relying on the concept of sovereign immunity. And this creates a huge problem for all these options. Recently, one additional options has arisen on the horizon. And we talked about this option long before. This option is like special claim commission. And in November, the United Nations General Assembly voted to create, I would quote, to recognize the need for the establishment of international mechanism for reparation for damage, loss, or injury arising from the Russian Federation and internationally wrongful acts, and it also recommended member states to create an international register of damages to serve as a record of evidence and claims information. Why it was General Assembly, you could ask? Because, you know, we have some historical examples of this special claims commission, and none of them was created by the National General Assembly, as far as I recall. The problem is that all the existing precedents were created either with the consent of the respondent state, which is not the case in our situation, or with the blessing of the Security Council of the United Nations, which is also not the case in our situation, because Russia is still sitting there. If we somehow could, as following Ukrainian call for action, stop Russia from enjoying the rights of the USSR, because you cannot expel a state from the organization if the state has never properly become a member of the organization. And this is actually the case of Russia. Russia has never become properly the member of the United Nations as such, and of Security Council in particular. So that is why Ukraine formed it as stop using the rights of USSR. But in any case, now we have the situation with the Security Council is malfunctioning, and when the Security Council blocks some decision, we have this way out to put the decision on the voting of the General Assembly. And in our case, General Assembly supported creation of this mechanism. But again, this is just a declaration. The mechanism is yet to be established. And what is more important, it would be only effective if it would be somehow backed up or supported with the funds. So the mechanism itself, even if we have a legitimate jurisdiction recognized by the international community, would be useless if we don't have money in the end. And again, this is not a cheap mechanism to establish. We all should understand that that would be long and costly exercise. And we, of course, need to move in that direction, but we need to think about the end of the story, and we need to think about the money to be recovered from Russia, despite the absence of its consent and any willingness to pay. So General Assembly invited Russia to pay reparation, but the Russian reaction is it is no. Say it diplomatically. Now we go to the core issue of our discussion. We see that all existing legal avenues, all future legal avenues, they all depend on the issue of jurisdictional immunity, because Russia has hundreds of billions of dollars placed in other jurisdictions which are safely covered by the jurisdictional immunity. And so far, Russia has been very successful in using it. And it actually creates a situation when Russia, being wrongdoer, being a state violating fundamental principle of international law, enjoys at the same time the rules of the same system of international law, which says that, as we know this Latin maxima, parem parem non habet imperium. And so equals have no sovereignty over each other, which is one of the general principles of international law, and which is embodied in the Article 2.1 of the United Nations Charters. As well, as it says that the organization is based on the principle of sovereign equality of all its members. And so we all know that because of this principle, a sovereign state cannot exercise jurisdiction over another state, sovereign state. And we all know there are some exceptions on domestic law and international law from these principles. If you look at, and of course, as Ukrainian lawyers, we have already discussed various exceptions available on domestic law as a potential, from potential enforcement perspective, at least for those Ukrainian judgments or potential arbitral awards against Russia. And we see that various exceptions could include, for instance, general tort exception, sponsoring of terrorism, probably some other. None of them mentions a crime of aggression, and many of them, if not all, require a territorial nexus, either of the wrongdoing or losses, or some element of that, or jurisdictional, claimant should have some nexus with that jurisdiction. So it's not a universal jurisdiction, put it in other words. And probably the only jurisdiction which now considers otherwise is Ukraine, with like new jurisprudence of the Ukrainian Supreme Court. All those, if we're looking again from the perspective of enforcement of Ukrainian judgments, all those exceptions are not uniform in different jurisdictions, and they might require different reasoning, even from the Ukrainians' court perspective, in order to have at least some chances of to succeed in other jurisdictions. And if we look at this from the background of the situation, and also the gravity of different violations now being basis for exceptions. So we have terrorism and we have tort. If we compare crime of aggression and crime of terrorism, from international law perspective, it's quite clear that the international crime of aggression is one of the gravest crimes in the system of international law in general. So its gravity is much, much higher than the gravity of the crime of terrorism. Again, with tort exception, tort is a quite general issue, not comparable with the crime of aggression. And why we have an exceptions for such, call it light violations, and we do not have exception for such a huge violation of international law. It's even more strange that we have in our situation, it's not only our Ukrainian opinion that this is a crime of aggression. So the entire world has recognized that this is a crime of aggression. The General Assembly of the United Nations has recognized that this is an aggression in violation of the United Nations Charter. And still, there is no answer how to deal with that. The obvious answer to that is that we need somehow to change the system. And we see two basic ways how to do it. One way is to go on the domestic level. For instance, so this is not exactly about sovereign immunity, but still related topic. Canada has passed a law allowing to repurpose the assets of sanctioned entities and individuals, sanctioned because of the war in Ukraine, and to use the proceeds in several predefined purposes, including to compensate damages of the victims of war. And I would say that it was quite brave act for Canada, which has opened some new ways to get access, at least to some Russian monies, at least to the monies of Russian oligarchs connected to the ruling regime. However, so far, other states have not followed Canadian example. It's still possible to do that. So Canada used, actually, the entire changes in its law was done under principles also of human rights and some like fundamental values like that. I do understand that other states decided to wait, probably to see how it would develop, because again, any drastic changes in legislation or any acts of confiscation of Russian assets could potentially lead to some negative consequences for those states, like investment treaty cases brought by Russian investors, or in generally affecting reputation of that state as being safe place for assets of some other investors. And that is why until recently, the general position of many Western countries was quite skeptical, and they were waiting for some new developments. Last week, there was a good news from the European Union, and there was a statement that they are working on the solution to find a way to somehow repurpose the Russian frozen assets. And this covers not only frozen reserves of the National Bank, but also frozen assets of Russian oligarchs. And as stated in this statement of the, I think, president of European Union, it was through an international treaty. So the mechanism, as it would be expected, it is international treaty. And actually, Ukraine, as we know from the Ministry of Justice, was advocating this solution as well. I mean, change via new international treaty. And again, if we compare and come back to how to get to the new reality of how to tailor the existing concept and to the new reality, except for domestic avenue, there is an international avenue as well. Treaty is most obvious option, because for international customary law, you need probably more time, and this is not straightforward. Because with a treaty, you could have a text, you could adopt it, and you could ratify it and implement it. That's it. And when you have an international treaty, this would probably help many states to finally take some actions with regard to the Russian assets, because it would be like international law, and that would be a good, not excuse, but a ground to make an exception from the existing rules, and to avoid any potential claims of Russian investors, etc., etc. The critics of this, I have discussed this option already with many lawyers, and actually I have discussed both options, domestic law avenue and international law avenue, and many lawyers in many jurisdictions are still skeptical with regard to both, because probably this is nature of humankind when you are opposing any changes, especially if this concept has been a part of the system for a very long period of time. However, if we look at the situation from a different angle, so international law is not something like written in stone. It has been changed already many times, and one of the major changes took place after the Second World War. And probably the war in Ukraine now should be a trigger and should be a turning point to reconsider existing system, to reconsider this system of balances between force and economy, to find a new balance with the help of new exceptions or new tools or new mechanism. And in my view, one of quite effective tools would be to reconsider the concept of it, state in unity, because this would open the floor, this would open the door to take assets of state committing violation of fundamental principle of international law in order to compensate the end result, the consequences of that violation. So it's not like just depriving that state of its assets. It's like repurposing the assets just to compensate the damages committed and caused by the same wrongdoer. So I think the logic here is quite clear, and it should not be seen as abuse. And we see that there is a general and absolutely united opinion that Russia has committed a crime, and everyone, I mean, civilized world has recognized it, and there is no room for any discussion whether it's so or not. Yeah, and we all see the devastating consequences of this war in Ukraine, and these consequences should be somehow liquidated, and the damages should be compensated. So I think the solution is that easy. So it's like on the table. You just need to take it and to make it and to implement it. And you need to have courage for that. You need to have political will for that. You need to accept that, okay, that might be a new reality, that might be a solution. And what is important, this might be a much important, I mean, economically, this would be not comparable with the existing sanctions regime. I mean, in terms of money, like hundreds of billions of dollars of Russian assets, and their repurposing would be quite important. Even so, if done now during the war, it could change the situation even in Russia now, because I mean, this would change the landscape, financial and legal, of the situation and public opinion in Russia with regard to the actions of their rulers. If it's done after the war, again, it's highly important to send a strong signal to other potential aggressor state. We see some hot situations already in geopolitical context. And okay, we are now living in a world that we don't know where to expect problems. So a year ago, I did not believe that I will live in a war during the next year. So you never know. And we need to send a strong signal to these potential states that they will lose a lot. They will lose probably their defense or benefits. One of the major benefits of international law they have now being compliant with international law rules. And this would be important. So you cannot be prepared for the war, but you could learn your lessons, and you could somehow improve the situation now in order to avoid further wars, using someone's experience like we now have with Ukrainian experience, and the world has changed this opportunity to introduce these changes and save itself from chaos of war, of new wars in future. So stay with Ukraine, help Ukraine to win and hold Russia liable. And as we say, Slava Ukraini, glory to Ukraine.
Thank you so much, Olena. You know, that is such an interesting and inspiring way for us to be thinking about really tough issues. You know, I loved some of the insights, and something Mandi and I have often discussed, you know, lawyers don't like change. We just don't like change. And, you know, how do we really confront these new realities? Because some of these issues of the fundamental imbalance in the rules we have known. But it's, I think, getting back to the point you had suggested, you know, it's kind of working, let's just leave it. So thank you very much for sharing these insights, you know, truly. And we definitely all pray that there is peace immediately. You know, we cannot forget that reality, that lives of people are at stake. Well, and I know we're getting close to the time and it's late for you, but perhaps there's one question, you know, when you were talking about state immunity, right? You had, I think, nicely outlined the international framework and the domestic framework. And it's perhaps just teasing this out, you know. A lot of the jurisdictional immunity and the enforcement immunities are through domestic laws, right? You have the Foreign Sovereign Immunity Act in the US, the UK Immunities Act in the UK. Is the idea, therefore, to have like a global treaty that would make a narrow exception applying to all these countries, because every country has its own regime, its own reality, right? How would you try to operationalize this? If you had any insights, we would love to.
So it's even not about the insights. The problem is that even if we have a treaty, let's imagine that we have a United Nations Convention introducing some new exception to state immunities. So you cannot bind the state, without the consent of that state. So they all need to be willing, to join the treaty and to implement it. So having a treaty as such is not a solution. The solution is to have it implemented. And in order to have it implemented, you have actually two ways: either to have this coverage of or having this basis of international treaties and then just ratifying it, implementing it on national level, or you could do otherwise. You could choose your own way. You could introduce your own exceptions on national level, either just relying on some international law rules without formally accepting the rules of the treaty. It might be done for different political reasons, for different geopolitical reasons, and some acts committed in the past and probably contemplated for the future. And there could be some political reasons for not doing that. We understand this. And that is why there are plenty of opportunities. The more important is the end result. And I don't think that would be a uniform decision. I think some countries would go, it's like, I don't know, in arbitration with model law. You have a model law, you have, or you have your own rules. And actually in the common law jurisdiction, you don't have model laws. You have your own rules, and all these foreign immunity acts are typical for common law jurisdictions. So civil law jurisdiction play differently in this area. So I think it would be good to have an international tool, just to have like a common ground of what should be done. And to put it more broadly, it's not only about aggression. So the aggression is probably the salient, the most obvious exception we could have. But now, actually in Ukraine, we now have the threat of nuclear contamination or some attacks. We have a lot of climate change issues. We have cyber attacks. We have a lot of new developments, again, not entirely covered by existing international law rules, and they might be addressed in one way or another in EU treaty or in EU domestic rules. So as I've heard insights from the Minister of Justice of Ukraine, they're working on international treaty. I have not seen any draft, I should confess. I would be very interested to see one. But in any case, we could all contribute to the discussion, to the creation of this mechanism. So it's like a quite interesting time for lawyers when you could contribute to creation of a new system. And the most important is that we are willing to create such effective system in the future and to implement it properly.
Thank you so much. Thank you, Olena. That's, I think very insightful remarks. And thank you also, the implementation and not just thinking of good rules. Thank you for sharing that, because, that is the end outcome we want as lawyers, not just having good rules. So thank you. I'll pass it to Mandy for the next part of the show.
Thank you very much, Kabir. Olena, let me just echo Kabir in saying thank you so much for taking the time to share your insights practically from the front line and for taking the time to join us on TagTime today. Now, as our audience will know, this is traditionally the part of the show in which we ask our guests to tag their successor in the hot seat and choose who we will be hearing from in a future episode of our show. However, as we explained last week, we are witnessing the dawn of a new era. Our show, TagTime, is evolving. And after all, the word tag has many different meanings, depending on the context. To social media users, it's an act of identification and connection. To children, it's a playground game. Tag, you're it. It's a means of passing the proverbial baton, but it's also a means of identifying things like pets and cars. Those who like to keep the discussion going may tag a question or a comment on at the end of a discussion to add further value or to inspire debate. The tag of a graffiti artist is a signature of sorts, a way of marking that which they've created as their own, even if they wish to keep their identity secret. All that we ask is that you have faith that, like James Bond, we will be back. So please tag along with us and stay tuned as we take tag time to a whole new level in 2023. And with that, season 6 of Tag Time draws to a close. Thank you to our audience for taking the time to join us. You're going to do ha 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 again. I was just thinking for a second. If you registered for today's live episode, you will receive a link to the recording of this webinar in due course, accessible for a limited time only, and thereafter via Delos's members area. Remember, if you are searching for something to watch over the forthcoming holiday season, you can always catch up with recent episodes of Tag Time and other Delos programming on Delos's YouTube channel and otherwise via its member area. If your New Year's resolution is to hone your advocacy skills, remember, Delos will be opening applications for Rope Asia next week. You don't want to miss that one, folks. And as we've reached the end of yet another season, are you all sick of this yet? We would be remiss if we did not thank our dear friend Hafez Verji, who is the president of Delos Dispute Resolution. And after all, without him, none of us would be here today. Thank you too to those behind the scenes at Delos who provide us with the technical support that we need to keep the show on the road. So thank you to Gazelle and Ezekiel. We will be back one way or another in 2023. So please do keep an eye on Delos's website and social media feed for further announcements. And until then, thank you all for listening today throughout season 6 and over the last, is it 3 years now? Nearly?
I
think it might be 3 years or so as our series has taken you on a whistle-stop tour around the world of arbitration. I said it at the end of our last season, and I remain convinced that world domination approaches. We remain enormously grateful to everyone who has tuned in, who tunes in, and we truly appreciate all your support and engagement. We also quite like meeting our fans. Yeah. We have fans. It's really cool. We have fans. We get to meet them now as we travel around the world. So thank you. Come and talk to us. We're quite nice, we promise. However you celebrate, we wish you a fantastic holiday season, and we'll be waiting for you all on the other side in 2023. So stay safe, everyone. And I'll now hand you over to Kabir to say his traditional goodbye.
Thank you, Mandy. Let me just begin by thanking Olena for joining us. You know, Olena, the situation is really hard. And I mean that in the, I don't think those words do justice to even come close to describing what's happening on the ground. We pray for peace and we thank you both for joining us, but also for all your efforts to promoting the rule of law and to promoting peace. We really do deeply acknowledge with humility everything you're doing. As you said, Slava Ukraini. I hope the pronunciation.
You should reply Geroyam Slava, Slava to heroes, or glory to heroes. So it's like a reply to that words. Yeah, thank you.
Let me also express my thanks to all our awesome audience members, to Hafez, to Ghazal, to Ezekiel, to everyone working behind the scenes. We're grateful to each of you. Season 6. And Mandy, we did season 4 last November together. We have done season 6, the last episode together. Can't wait what season 7 has in store.
Who knows where we will be doing
who
season
knows?
7,
yeah,
what jurisdiction we will find ourselves in. We'll probably be at the top of the Eiffel Tower or something like that. Who knows?
But we just take this moment to wish everybody happy holidays. We take this moment to pray for world peace all around us. And we look very soon. Thank you, folks. Stay safe. Bye.